Thank you, and good morning, everybody. It's 9 a.m. on Tuesday, March 10, 2026. And welcome to day 9 of our hearing on Lake Forest Park's Lakefront Park improvements applications and SEPA appeal. Before we continue with Mr. Anaker's cross-examination of Mr. Hoffman, I have one housekeeping business to take care of. Yesterday, if I recall, it was late in the afternoon, I received an email from Ms. Pratt transmitting 4 email comments that the city had received, and I believe she sent that to the rest of the parties at the same time she sent it to me. I will now enter those 4 comments in the record in the time order in which they were received by the city, lacking any other logic for what order to put them in. So we have the following comments now added to the record. Exhibit 67, a comment from Lisa Golden. Exhibit 68, a comment from Hannah Blackburn. Exhibit 69, a comment from Lisa Hill. And Exhibit 70, a comment from Lisa, I probably will pronounce this wrong, but Koreis, K-O-R-E-I-S. Koreis, something like that. I apologize if I have butchered her pronunciation. All right. When we adjourned Friday, Mr. Anaker was cross-examining Mr. Hoffman, and we'll continue with that. I would just simply remind you, Mr. Hoffman, as I'm sure you know and realize, you're still under oath.
Yes, sir.
Mr. Anaker, go ahead.
Thank you, Mr. Hearing Examiner. Good morning, Mr. Hoffman. How was your weekend?
Good morning. It was good. Thank you.
Good. All right. Let's just jump right in here. Okay. So I am sharing my screen. I believe this is Exhibit 39. And it is the staff report for the Lakefront Park improvements. Correct, Mr. Hoffman?
Yes, that's what I see on the screen.
All right. And we'll go all the way down to the bottom. And this is PDF page 51. Bates number 1009. And this is your signature, correct?
It is.
Okay. Now, did you draft this staff report?
Typically the project planner, the person most involved, drafts it, and then it's reviewed by the community development director and SEPA responsible official.
Okay. So we are now going to go to page 9 of this document, which is Bates number 0967. And I'll represent that this is generally a discussion of the critical areas on the project site. And I'll direct you to the 3rd full paragraph on this page. And I'll represent that paragraph states that the proposal includes planned recreational improvements within portions of the on-site stream and wetland buffers pursuant to SMP appendix sections 330A, 350A, 350G, and 360, including a variance request for a reduced stream buffer. So it identifies section 330A as the basis for allowing impacts to buffers. Is that a fair characterization?
I do believe it's 320 and 330.
Okay. Where is 330 identified? Or pardon me, where is 320 identified?
In the SMP.
Okay, but not in the staff report.
Well, it's not cited on that second line, if that's what you're asking.
Okay. But Appendix 3, Appendix A, Section 320 of the SMP was part of the consideration when deciding to recommend the permits for
The
approval?
entire SMP was considered.
The entire SMP was. Okay. Do you know why Section 330A was specifically called out here and not the others regarding wetlands?
Because that's where the word exception lies.
Okay. And so that is the provision that provides the exception then.
Well, as you see in the first bulleted item, it's the first sentence, yes.
Okay. Stop sharing for a second here. So we have heard testimony that this project cannot function as intended if park users are unable to access wetland B. Were you aware of this fact when you were reviewing the proposed permits?
I was aware that public access is the primary project proposal.
But specifically to the area delineated as wetland B, were you aware that access to that was necessary for function of the project?
As it's included in the shoreline for the site, yes, I consider the whole shoreline.
Okay. So we're going to So I've shared my screen again, and it should be the Lake Forest Park Shoreline Master Program. Is that what we're seeing here?
Yes, SMP page A-20.
Yes. Okay. And section 340 wetlands mitigation requirements. That's the name of the section? And did you determine in your review of the proposed project that it met the mitigation standards of 340?
I did.
Okay.
For a disturbed site, not a pristine natural site.
Okay. So scroll down to the next page and section E of, or subsection E of 340. The last sentence, minimum requirements for enhancement shall be established in administrative rules. Do those administrative rules exist?
As they pertain to the SMP or the critical area ordinance or the comp plan or the Shoreline Act or the GMA, yes.
Okay. Where can we find them?
It's throughout the SMP would be my answer.
Okay. But there are not a separate set of administrative rules established for shoreline enhancement of wetlands.
For the shoreline jurisdiction, no, the SMP is that document.
Okay. So one of the requirements for a grant for a shoreline variance is that the strict application of bulk dimensional or performance standards set forth in the master program precludes all reasonable use of the property. Is that a accurate paraphrase of that requirement?
Well, I have the staff report printed in front of me, but more or less, yes, that's one of the findings.
Okay. Is there any written guidance in Lake Forest Park for how reasonable use is defined?
Well, as you see in the staff report in the SMP, it touches on it. I don't know that it's an analysis comparative to case law or anything of that extent, but yes.
Okay. But there is no standing document that explains in Lake Forest Park, we believe that reasonable use is defined as this outside of the SMP.
It has WAC and RCW references, which are much more extensive, and so yeah, those would be another source.
Okay.
The SMP does talk about that the reasonable use exception tool from the CAO does not apply in the SMP.
And do you have a working definition of reasonable use that you follow routinely?
I tend to be more land use oriented, yes.
Okay, I didn't quite understand what your answer there meant. You said you tend to be more land use. What do you mean by that in the context of reasonable use?
Usually it comes up in a pre-application meeting or a discussion or application of the code for the permitted uses in zoning.
So you don't usually consider it in the projects that you approve, or in this case, recommend for approval?
Objection, that's not what he said.
Okay, well, I'm trying to figure out what he said then. Mr. Hoffman, could you explain further what you mean by that?
I would use an example. Most of the projects that we get in Lake Forest Park are residential, remodels are new, and you go to the zoning permitted uses and you see that residential dwelling unit is a permitted use.
Okay.
A reasonable expectation or balance would be residential use.
Okay. Is there a similar provision where this is simply listed as a reasonable use?
If you mean public access in the Shoreline Act, yes.
Okay. Does that refer to, does that recognition of public access being a reasonable use, is that recognition a broad, any public access is a reasonable use, or is it narrow and the minimum public access is a reasonable use?
There's a definition of public access. It includes touching the water, swimming, viewing.
So any use that would achieve those, and I think you did earlier testify to that definition, any use that would meet those requirements would be a reasonable use.
I wouldn't use those words, no.
Okay, what words would you use?
I wouldn't use the word any. I would use this project proposal.
So do you think that there is no reasonable use of this property within that definition that has a pier that is either a pier that is smaller than the one proposed?
The SMP is both comprehensive plan and development regulations, and so I believe this project is the reasonable use.
Okay. You said the reasonable use, the only reasonable use?
Based on past testimony and the extensive design, this is the reasonable use.
So there's no reasonable use of this property possible without a pier at all.
For the definition of public access, I don't know how you touch the water from Beach Drive.
Okay. But we had lots of discussion about people passing through wetland B in order to reach the beach. Isn't the beach at the water? Can't you touch the water from the beach or from wetland B?
I think the Shoreline Act is more expansive than that.
Okay. So that's just not sufficient touching of the
Objection.
water.
He has answered this question. Said public access requires more than that.
I'll sustain. It's close, but I'll sustain.
Okay, I'll keep going. There's also a requirement that any hardships not be of the applicant's own making, correct?
Yeah, I don't know the exact wording, but that is one of the findings, yes.
Okay. So the hardships requiring a variance here are not based on the city's own wants for particular park amenities?
No, they're based on the natural character of the site.
So is your testimony that the critical areas ordinance of Lake Forest Park also applies to the critical or sensitive areas within the shoreline jurisdiction in Lake Forest Park?
The Appendix A and the SMP represent sensitive area review for the shoreline jurisdiction. Any project also has to be compliant with the Lake Forest Park Municipal Code.
Specific, but let's think about it this way. If there is a provision in the shoreline master program that conflicts with a provision in Lake Forest Park's critical areas ordinance, which applies to a wetland within the shoreline jurisdiction.
The key word is conflicts, so they have to exist in both, and then the more stringent applies.
But if there is a provision in the municipal code as well as the master program, and they do not conflict, do both apply?
I'd have to analyze what they are.
So you testified a little bit about your consideration of trespass concerns. And I believe you said that the water is public. Is the lake bed also public?
In some cases, yes, but I believe in this case, the subdivided lot along the shoreline continues out into the lake.
And the water there is fairly shallow, correct?
I would agree.
So there is a chance that somebody wading up to the buoy could also partially cross onto the neighboring private property lake bed then.
I know the purpose of the buoy. Could somebody walk along the shoreline? Probably, yes. There's also the bulkhead, and then sand accretion, and then the neighbor's dock. And so in that context, it's not a clean or clear transition. But if you're asking if the sediment in this shallow condition continues eastward, the answer is yes.
Would applying a setback to the boundary swimming buoy of, say, 15 feet still allow for public access to the water while better protecting neighboring property concerns?
For what purpose? There are no structures proposed there.
I'm not certain that my question got across there. My question was that, and we've recognized that trespass is possible with a buoy on the exact property line on the.
I'm going to object. The question was, is there a chance that someone will walk onto the Fudge's property? That was the question. A
That
chance.
was not my question, Miss.
You didn't use the
Brad.
word trespass.
I am explaining better because he answered a question a way that didn't make any sense to me, and now I'm rephrasing it.
Okay,
Something-
now the word that struck in my mind was where you, in the rephrasing, said that the buoy was right on the property line. In your earlier questioning of him, you did not make that specific statement as to where the buoy line was.
Understood. I see. Okay. I see. So I will rephrase my questions in hopes. So, by way of introduction to this question. No. Okay. Let's do this. Is trespass on to the Fudge's lake bed property possible when there is a buoy line that is along the property line?
Yes.
Okay.
Particularly from the east.
If the buoy line were 15 feet set back from the property line, would there be less of a chance of trespass?
I don't believe so. I believe the buoy line at the property line is the tool and mechanism and should be adhered to. There are no structures, and it's a use, and people can float and use the lake and the water and touch the gravel underneath that water on the park parcel. And the buoy line is intended to show, hey, this is private property adjacent. So I believe it's a draft condition. At this point, we don't know that the buoy line is going to be on that property or 150 feet. Our suggestion is that be the case.
if the buoy, which you do recognize is currently just a draft condition, but were the buoy 15 feet set back, would that still allow for the public access to the water?
I don't believe so. I believe the public access includes all the way to the property line for swimming.
So, and this was last week, so do correct me if I get something wrong here, but I believe last week you testified that you were the decision maker on whether or not to continue, whether or not to have the your traffic expert conduct a study on Beach Drive itself, correct?
I was the decision maker to not pursue additional measures to address existing conditions on Beach Drive and SR 522. Yes.
So you said existing conditions there. Do you mean, did you mean whether or not to plan future mitigations or to simply analyze what is happening in Beach Drive right now? What was the goal of the?
We're public servants. We really honor public comment. And the thought is that we're not in the business of creating negative impacts, but in our project review, the proposed public access park, needs to mitigate its impacts. It does not need to fix existing conditions or anything of the sort. The additional work would have addressed some of the comments or some of the possibilities for a new on-ramp to fix the U-turn for the dentist, to punch Beach Drive through to either direction for some reason to look at through traffic or access. And that was not needed to analyze the project impacts.
So there was no study that analyzed project impacts specifically on Beach Drive then?
There was.
There was. And what was that?
The TIA done by Transportation Systems.
So if
Harrison.
if the analysis was not in the TIA, then that analysis was not done.
The analysis in my mind and my position was done. The TIA is the primary report that was relied upon.
All right, and we are back to our old friend, the Shoreline Master Program. We're on page, looks like B21, which is PDF page 199. And I direct your attention to B7.7, which is priority 7, acquisition of shoreline property. And the part that I like to ask you about, because I think you did address this on Friday, but the idea of that is the last clause after the comma there, and constructing demonstration shoreline restoration projects. Do you consider this project to be a demonstration shoreline restoration project?
Absolutely.
Okay. And why do you think that?
The enhancement of the existing preserve, the very design that was that took into account all of those variables, restoration, enhancement, removal of a small portion of bulkhead, replacement of two docks to a more sensitive design, or excuse me, new pier. I keep saying dock. And so I do believe that the project fits priority 7.
Okay. But it includes, but as we've had testimony, it includes an expectation that wetland B will be used by park goers. There's no concern that that will create a precedent for future development along the shoreline in Lake Forest Park, where wetlands can be used as a route to the beach.
Not for this project. No, wetland A extends onto the property to the east, and it's not fenced either.
But wetland A isn't right on the beach. There's no expectation that people will be using it as a route there.
I'm not sure what you're asking.
I'm asking whether or not wetland A is likely to have people entering it for the purpose of getting to the beach.
Not public, no.
Okay. But we are expecting people, the public, to be entering wetland B for access to the beach.
Oh, if you're saying walking is not an alteration, that's correct.
So you're not worried about a future proposer of a project along the lakefront saying it's okay that people pass through this wetland, just look at lakefront park improvements. It was allowed there.
The very design channels or funnels public access through the center is a balance between the residential character on the east and the preserve on the west, provides public access and avoids and does not alter wetland B.
So I put up exhibit 030. We're looking at first page of that document, which is 0890. This is the notice of determination of non-significance with mitigation measures for the lakefront park improvements, correct?
It appears to be, yes.
And down on page 0893, that is your signature, correct?
It is, yes.
Okay. And did you draft this document?
I'm responsible for it, and the final drafting, yes.
Okay. Okay. And so you are the responsible official on the project?
I am, yes.
So we're on 0891. You reviewed the SEPA checklist for this MDNS, correct?
Yes, sir.
Okay. And at the top of that page, there is a list of, it looks like 12 environmental documents. You reviewed these environmental documents, correct?
Each one of them, yes.
Did you review any others?
I reviewed it, the entire application materials and record that I had on hand.
Okay. And when did you make the determination of non-significance? It looks like it was published on October 16th.
The threshold
2025?
determination was made on October 14th, 2025.
Okay, sounds good. And did you review more documents than this with regard to the MDNS on or prior to October 14th?
Yes.
Okay. Which ones?
The SMP, the Critical Area Ordinance, the Lake Forest Park Municipal Code, the Comprehensive Plan, RCW, WAC, the application materials, everything I had on hand.
Okay. Application materials. What did you review there?
The narratives and the actual application form,
Okay.
even though it's just informational addresses, contact.
Okay. Understood. Okay. So it was those narrative forms and then I would call them authorities. Is that
Right. I don't know what you're referring to as authorities.
fair? Legal authorities, the SMP, municipal code, etc.
Policies, goals, and development regulations, yes.
Okay. But no other reports or anything, correct?
Objection, he said everything he had on hand.
Sustained.
When you say that you had everything, you reviewed everything you had on hand, did that include any reports regarding environmental considerations that are not listed here? And I'm not including in there legal authorities such as the RCW, the SMP, and I'm not including application materials such as the plan permits, the permit narratives, or the plan set.
Yes, one of the primary things I reviewed was the notice of application comments from the public. Those did not include new reports, new analyses, or anything of the sort. Also, the WAC allows me to request additional information and collect information with a site visit, which I did.
Okay. You said that you collected additional information and did a site visit. Excluding the site visit, what other additional information did you collect that we haven't already discussed?
I would describe, it's been 2 years or a year. I would describe that as my daily work as community development director in the community. Relevant information from other reviews, relevant information from other processes, specific to, well, give you an example. What utilities serve the site? Is it Seattle City Light? Is it city sewer? Is there a regional sewer line out in the lake? Those are examples of what I do on a day-to-day basis.
And did you document that anywhere?
I documented what was needed for this project review. And then I considered it my best due diligence to do the threshold determination.
And in making that threshold determination, you determined that significant environmental impacts would be mitigated, correct?
I included mitigation measures, yes.
Okay. What were the significant environmental impacts that you identified?
They're identified in the staff report and then the draft conditions of approval. They are contained in the critical area report, the BE, the TIA.
So, in issuing and I'm going to just refer to it as the MDNS. I believe we all know what that means.
Yes, sir.
So in issuing the MDNS, you relied on the city's wetland delineation dated March 2020. Oh, I'm sorry, December 2023, correct?
I'm just checking the date on my list. December 4th, 2023, yes.
And you relied on that same wetland delineation when you reviewed and recommended approval of the permits, correct?
Yes, sir.
All four of them?
All four of what?
The permits.
All the permits that are before the hearing examiner, yes.
Hypothetically, if there were errors in the wetland delineation such that minimum buffers increased, would that change your determination on any of the permits?
Is this
Yes.
a hypothetical?
It is a hypothetical. I started it with the word hypothetically.
And then you got very specific about this site.
It's a hypothetical question.
Can you please repeat that?
I can repeat it. Hypothetically, if there were errors in the wetland delineation such that the minimum buffers increased, would that change your determination on any of the permits?
Well, I'll answer that with I'm not the decision maker, but the Lake Forest Park Municipal Code and SMP has a provision that if erroneous information were relied on, that could be the case, but it depends on what it is. And so if it's just part of the review or an alternate scenario that has no impact, then maybe not. But if it in the end affects the actual decision or action, then hypothetically, yes.
If that were the case, would your MDNS have been made with sufficient information?
As it pertains to this project, this is not a pristine site. This is not a classic natural shoreline that's proposing new development. So the review and analysis would depend on nonconformities, areas that are already extensively disturbed, overlapping buffers. So this is a rather unique situation. So it's hard to answer hypothetically.
Hey. And your threshold determination was also relied upon the biological evaluation, correct?
It did, yes.
As well as the critical areas report?
Yes, sir.
And you relied upon their assertions of no net loss.
I did, yes.
Were there were there quantitative performance standards in the mitigation plan in the critical areas report?
Yes, sir.
There were.
Yes, sir.
hypothetically, if those assertions of no net loss were not well founded, would your MD&S have been made with sufficient information?
It's hard to tell based on the situation, the design, the existing site conditions, and what the issue would be. A slight difference or another issue that's consistent with the analysis may not be. Depends on the degree. If it were severe and all of a sudden a wetland D in the middle of the site were discovered, that's a different scenario, but we did not review that in that context. We reviewed it based on the information that we had.
All right. We're going to just switch over to Exhibit 006, which is the SEPA checklist. And this is the SEPA checklist that you reviewed, correct?
The exhibit list shows it as January 9th, 2025, number 6.
Yes.
Yes.
We're on page 0091, which is PDF page 4. And I believe that you testified that there would indeed be increased vehicles at the project site after it was complete and operating, correct?
I don't know if you're reading, I can barely read that, but if you can blow it up a little bit.
I wasn't actually reading that. I was referring to testimony you gave last week. Is it fair to, but I can just ask it again. Will there be additional cars coming to the project site when it is operating as a park?
Yes.
And those cars will be producing emissions.
Yes. Yeah. Until we all convert to electrical vehicles, the assumption is very much yes.
So in the SEPA checklist, I did not see any discussion of those continuing operating emissions. Did you consider those in your?
Yeah.
You did.
Apologies. I did. Yes.
Okay. Where is that documented?
In the threshold determination that there's no significant probable adverse environmental impact. The design and the materials and the drawings and my site visit and the TIA and the trip generation numbers show that it's pretty small. It is public access in a park, so there will be more cars accessing the site, but the emissions due to 10 parking spaces and that peak hour do not rise to a significant probable adverse environmental impact. Hence my MD&S.
And so we'll just move on. Regardless of the specific percentage, there is an increase in the impervious surfaces on the site, correct?
Yes, sir.
Okay. And hypothetically, if the wetland delineation understated wetland boundaries, that would understate buffer protections related to surface water, correct?
I'm gonna object. The witness explained this is a complicated site and he couldn't answer these kind of questions hypothetically.
I'll sustain.
So regarding item 8, which is on page 0095, noise considerations. In any of the environmental documents, is there any kind of quantification of the noise that will be produced from recreational activities on the site?
No noise analysis was required or performed.
So similarly, no analysis of parking lot or event noise.
There are limitations to those capacity parking spaces, so it's self-limiting. Noise is mitigated through the Lake Forest Park Municipal Code, which cites the specific WAC section for receiving sites, transmitting sites, adjacent residential, and so forth. The other limitations include that Lake Forest Park uses its parks dawn to dusk.
And regarding, really quickly, energy and natural resources, you testified that there was no shadow analysis done.
There was no solar analysis required or performed. The Fudge residence has existing solar. There was prior testimony about 2 alder trees that are being proposed to be removed along that eastern property line. The project design and proposal includes solar on the community flexible use reconstructed building, and we're not proposing any trees that would preclude solar access for either.
Regarding the annex building, so then a little bit of testimony about the potential use for that. And I believe that well, here I'll just ask. Is a potential use for the site as a workspace for city employees?
As a traditional workspace, no.
Okay. So number 15, transportation, which is on PDF page 11, 0098. Just really quickly, it's been some testimony about Kenmore Air operating in the vicinity of the project. However, the checklist 15E says, will the project proposal use or occur in the vicinity of water, air, or rail or air transportation? And the answer was no. You were aware of the existence of Kenmore Air in the vicinity of the project, correct?
Correct. I see it every day when I bike to work.
Did you consider its presence in the vicinity of the project when completing the SEPA threshold determination?
I would characterize it as I considered it not to be in what I consider the project area. If you expand it to this general vicinity or region, the answer is yes. But as the Appendix B inventory shows, the majority, if not all, residential lots have docks and navigational challenges. Kenmore Air does not operate in the project area. We're not proposing that it does. So for SEPA, there's no environmental issue. The only relation to air transportation is for emergency purposes at the end of the proposed pier, for worst case scenarios. That's not commercial.
Finally, item 17, utilities on page 120099. So B of the utilities section is describe the utilities that are proposed for the project, utility providing service, and the general construction activities on the site or in the immediate vicinity might be needed. There's been some testimony about sanitary sewer upgrades happening near the project. Are these happening, to your knowledge?
If the testimony you're referring to is a future sewer lift station as part of a capital improvement or CIP project, yes.
Okay. How long has that been in planning?
I don't know. It's not my project. I have not done a planning review. I've been here 2 years. It's been in planning as long as the contract with Consort has been in place, which is relatively recent. But sewer replacement and upgrades have been considered, I think, throughout time.
Okay. So that contract, do you know which year it was entered into?
I do not, but I know that in 2025, there was discussion from Public Works to planning in preparation for a reviewable design for sensitive areas, critical areas, and so forth, and that they were working on project issues such as an underground vault or where to place the lift station. And they did some geotechnical borings last year in Beach Drive.
Okay. Do you recall what month of 2025 that occurred in?
I do not.
Okay. Do you know if those discussions of the plans happened prior to October?
Likely because in my memory it was warm and there's discussion about the Fudges moving their illegally parked boat trailer on Beach Drive so that a geotech boring could be done. And I associate that with summer, but I really don't know. With my workload, I don't know the month.
Okay. So you were aware of the upgrades at the time, the sewer upgrades at the time that you issued the threshold determination.
I was aware that there was a planned CIP project for a new lift station to serve Beach Drive, yes.
Okay. The checklist obviously does not list that project. Did you consider it in issuing the threshold determination?
I was aware of it, but the existing site and the 5 homes, or I believe 10 prior homes, are served by existing sewer service.
So you did not consider the cumulative impacts of both the park project and the sewer project upgrades together?
I did, and there's adequate sewer capacity to handle the proposed project.
One more here. Okay. So this is exhibit 010. This is a critical area study, correct?
Exhibit 10, critical area report revised September 19th, 2025.
Yep.
Yes.
Okay, and here is the section 6.7. This is PDF page 330156, and then bleeding on to 0157. And this is the monitoring program. You testified that there were quantitative requirements in the critical area reports plan. Can you identify where those are in here?
It's the critical area report itself. It talks about Appendix A, B, and C, incorporates them by reference, and then when you go to the exhibit, it's the table. And then the monitoring and so forth is in the text. It's in the report, and quantitative and qualitative. And so the overall report includes both. Appendix B is not an isolated report or exhibit. So in my mind, the attachment of exhibit or appendices A, B, and C are talked about throughout the report and is both qualitative and quantitative.
So Appendix A is the design plans, correct?
That's the title, yes.
And then B is the mitigation plan. And C is the impact analysis, correct?
That's how they're titled, yes.
I have no further questions.
Thank you. I may have a few. Mr. Hoffman, I don't remember whether or to what extent you talked in your direct testimony or cross about the city hall parking easement slash agreement that the city has with the owner of the shopping mall of which it's a part. But Exhibit 18 is a copy of that reciprocal easement. I'm trying to understand exactly what that easement does. Are you familiar with it? And can you enlighten me as to what it does?
I believe there's a date on there, 2000. So I am familiar with it, and my workspace is adjacent to it. Looks out on there, and so I see its operation. I shop at the Third Place Commons Safeway, so I understand it in that context. In preparation for this review, I've read it. It has two provisions that talk about that I believe it says the users of the city property can utilize the drive aisles and the parking spaces of the retail space, and another provision that says those users can use the parking spaces, drive aisles at the city property. And then it has a legal description of what the properties are.
Okay. There was, and I suppose I can try and open it. I'm not good at screen sharing. So I'm not going to try and do that. But if I went back to Exhibit 18, ah, every so often when I open up something that I haven't downloaded, the system tells me I have to download it to see it instead of being able to preview it, which is not pleasant. Where was that?
Mr. Examiner, I could share the document so Mr. Hoffman could see.
Yeah, let me find the part.
Okay.
Uh, it would be on PDF page 3 and 4. It starts at the very bottom of 3. It's the section in the agreement granting a benefit to the city parcel. And it uses the word associates, which is the name used in the agreement for the folks who own the shopping center. They grant to the city perpetual non-exclusive pertinent easement across the public access aisles and parking spaces on the shopping center property for the purpose of fire lane, pedestrian access, and vehicular parking. There was something in it that says vehicular parking. I'm not finding it right now, but I saw something that said it was for persons using the city parcel. And I remember when I read it, I thought, oh, does that limit the use to only vehicles coming to the property to go to City Hall?
I believe it
Do you
does.
have any opinion on whether that's the restriction?
I do believe that's the case.
So let me get this off my screen. Thank you. If I drove in and wanted to go across the street to the park, would I be able to use parking spaces in the shopping centers portion of the parking lot if I needed overflow? If the ones on the City Hall site were all full and I still wanted to go to the park, would that agreement let me park further to the west, down past the bank or in front of the other stores? Do you
I,
know? Do you have
I
an
think
opinion?
strictly speaking, it would not,
It would not.
because
Okay.
the park is not identified as the City Hall property. And then the 12 spaces for off-site parking are on the city property, and that would provide the specific parking. They could use any space on the city property for that. But as we know, there's another category in the summer, um, uh, multiple use. You can come to Safeway or go to Third Place Commons, hear poetry, and then walk over to Civic Club, or and so we don't manage that. And it occurs, I would say, frequently, but not as a custom. But as this agreement applies, the City Hall property would have to be the site for park users,
The user.
similar to Lyon Creek Preserve right now.
Okay.
It's similar to the 3 spaces on the city property right now that are signed for the preserve.
A real easy question. I think I know the answer, but I just want to ask. Is the 2013 SMP the most current SMP that the city has had approved by ecology?
It is, sir. Yes.
Okay. Would you tell me which part or parts of the project are subject to the SFAR application, the shoreline variance?
Uh, well, there's more than two ways to look at it. For sensitive area review, it's the shoreline jurisdiction, including associated wetlands and so forth, which more or less would be the whole site. For zoning, the portion that is not in the 200-foot shoreline jurisdiction is on the northwest corner.
So are you saying that leaving aside the part of the site that's outside the shoreline jurisdiction, and frankly, I don't think that matters because of a case that goes way, way back in history, the Merkel v. Port of Brownsville case, which says that if part of a site is outside of shoreline jurisdiction and the rest of the site is within shoreline jurisdiction, and if the part that's outside is inextricably linked with the part which is inside, then essentially the Shoreline Act covers the whole blooming thing. That's a very colloquial description of Merkel.
Yeah.
Um, so I'm viewing this that little corner. I made a rough guesstimate, scaling stuff off one of the drawings, doing interpolations to get my dimensions and what have you. That corner is maybe 5,000 or 6,000 square feet of the site that's outside the shoreline jurisdiction. So I'm figuring that the whole thing's covered by it. So you're saying that all development that's subject to the shoreline jurisdiction requires an SVAR?
Well, the shoreline variance is specific to the stream buffer and the dock. The shoreline CUP is for the dock and for some of the accessory uses.
What
I would
about
say,
what about all the development that's going on within designated wetland buffers?
well, the site is extremely disturbed, and so existing conditions and the SSDP, the permit to allow a park is the catch-all. Early in this process, we identified the shoreline jurisdiction, asked for an exhibit, and it showed that that northwest corner was outside. I think in my role as zoning administrator and shoreline administrator, if I'd known a case law, could have said that's shoreline jurisdiction and that a zoning CUP was not needed. I'm not aware of that. And so I viewed it as to have a public park on a portion of property outside the shoreline jurisdiction that a zoning CUP would cover that. It may be determined that that's not even needed. But if it's a coin flip, I'd rather have it there for review and decision because we intend to fully permit this park. And so I know sensitive area reviews, the entire site is encumbered and we looked at it that way. But for zoning, it could be argued a portion of the site's not in the shoreline jurisdiction for zoning, and that was the genesis of the zoning CUP.
Wow. I thought it was just the fact that the zoning code said that any public park on residentially zoned property required a CUP. I thought it was as simple as that. I didn't realize it was all hinged to the little corner in the northwest that's outside of 200 feet.
Yeah. And so that's how we looked at it. We wanted to be inclusive.
Okay.
And for
But the
sensitive areas, it
SR,
was a different matter.
but the if I wanted to build for whatever earthly reason, I don't know, um, 4 restrooms in a building on my lot within the shoreline jurisdiction area and within the regulatory buffer of a delineated wetland, not in the wetland, but in the buffer. Could I do that without getting, if it's in the shoreline area, without getting a shoreline variance?
I would assume so. It would be covered by the SMP. And then you have the pristine site versus existing site analysis. Residential is permitted use.
How does that affect the determination of whether a shoreline variance is needed? I thought the code somewhere, I could probably find it in my notes here somewhere, that anything that didn't comply with the requirements of the master program required a variance, a shoreline variance.
Yeah, not anything and that's the difference between the wetland buffer and the stream buffer is the wetland buffer specific provisions contain an exception. That's not a variance. The stream buffer section does not have that exception, so that's why it requires a variance.
Has an exception. Now, where's the exception? Which code provision?
The SMP code section 330 in Appendix A. And it's section 330 capital A.
Hey, hang on a minute. 310, 330. Where am I here? Okay, I'm just there. 160. $380. I haven't yet been able to figure out how to quickly maneuver through this. Let's see, that's 320. Here's 330A. Exceptions to the wetland requirements may be allowed only if it's determined by the administrator that the development site proposal will enhance or protect wildlife habitat, da, 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 da. And then subsection 1 says the applicant's going to submit a report. Subsection 2 says if the wetland's located in the flood zone. Subsection 3 says that you generally can't introduce non-native materials. And then B, sewer utility corridors may be allowed in wetland buffers only if C, joint use of sewer utility corridor is encouraged. D, surface water management activities are allowed in wetland buffers. E, you can't use wetlands for retention detention facilities unless it's regional. F, alterations to isolated wetlands only through an approved mitigation plan. And G, wetland crossings may be allowed subject to 5 criteria. So your reading of this is that A is just a blanket permission for exceptions to all wetland requirements, essentially at the discretion of the shoreline administrator if it meets certain performance standards, let's say. Is that right?
I would say it allows exceptions, but it doesn't apply all. I think it specifically applies to the the table that's before it in section 320 with the standard and minimum buffers. And then there's other language in there, except as otherwise permitted herein, alteration of any wetland buffer is prohibited. So I think it applies to that. And then it talks about buffer averaging, which we're not doing. It's a highly disturbed site. The lawn takes up a majority of those overlapping buffer areas. And so the exception is to the concept that if these were pristine buffers and we were proposing to reduce it to a standard and then exceed that, that might be a variance, but we're not. And so the exception is that we need to incorporate these highly disturbed areas.
Okay. So in 320A, Cat 3 wetlands with a habitat score of 20 to 28. And I realized that that's the old 2004 DOE functions number, and they've got a whole new one now. And DOE's put out an interpretation to convert from one to the other. But that habitat score is 125 feet for a buffer, and all other category 3 wetlands is 75 feet. We don't have a 75 foot, even a 75-foot buffer from wetland A, do we?
We do not have a 75-foot natural undisturbed buffer area for wetland A or B. We have a lawn. And so as you identify the required buffers and show those on a plat, that for that area is entirely already disturbed. So it's two different conversations. The code is written to take into account a pristine site, identify the wetland, identify the buffer, draw a line. That is not the case for this project, and it's not required to restore it to that condition, then apply a 75-foot buffer, then avoid it.
Okay. Interesting reading. Thank you. Um, you have said um, 2 or 3 times during your testimony in this hearing that you, as the shoreline administrator, uh, are empowered to take certain actions and decisions in the implementation of the act. And then you've gone on to say, but in the context of an application like this, which comes before the hearing examiner, you make a recommendation and essentially you stick the word examiner in place of shoreline administrator. Correct? Have I heard you correctly?
That's correct. The actual action or decision is the hearing examiner for Lake Forest Park.
Okay. Let me ask you, where'd that code citation go? 1855. Let's see, do I have that up here? I don't, but I've got 16. So let's go to title 1858. I said 55, but I meant 58. Off-street parking. 030. The last sentence, the one that's under the table. The parking requirements for a use not provided for in this section shall be determined by the city planning department, and such determination shall be based upon the requirements for the most comparable use specified herein. The reference to determined by the city planning department in the context of a project which is before the hearing examiner, does that authority transfer to the hearing examiner like the authority we just talked about?
I believe it does, and this is why I believe that. There are no parking ratios in the SMP. There are goals, policies, reductions, requirements. But this is a good example of a standard that applies from the municipal code to a project in the shoreline. And so this sentence, if it were not in the shoreline, would grant that discretion to the, in this case, the city planning department, in which case we would not just arbitrarily choose a number, but we would go to ITE and so forth and other examples. In this particular case, for the role as shoreline administrator, I can make certain determinations and move the analysis forward. The specific duties of the shoreline administrator, I believe there's 5 or 6 of them in the SMP that we can go through. One of those is to assist the hearing examiner. So in assisting the hearing examiner, that is not a decision or action. The decision would be the examiner instead of the city planning department for this project.
Okay, thank you. This is a devil's advocate question. I recall the testimony that the vegetation, and I think it was Ms. McClusick, it might have been somebody else, that the vegetation in wetland B is essentially all invasive stuff. And if we tried to get it out and replant it with native vegetation, we'd have one heck of a problem. That this invasive stuff, sort of like blackberries, would just keep popping back up again, pretty much no matter what you did, unless you literally dug down and ripped out the roots. Now, I think I recall that testimony from several days back. If that's a correct perception on my part of what I was told, then why, devil's advocate, why are we worrying so much about wetland B? It seems like it's more a problem than it's a benefit. It's filled with invasive species, if I've understood it correctly. It's not filled with native species. It's just this thin little strip sitting there that's going to get trampled over. Why? Do you have an opinion as to why we're all so concerned about wetland B?
Well, it's a sensitive area. It's identified in the critical area report. We're not proposing to alter it. I believe the testimony was invasives, but from my site visit, there's also a rusted chicken wire 2-foot tall fence through a portion of it. I assume we'll remove that. And we're not proposing to alter it. And I think it shows process, it shows avoidance, it shows preservation, as opposed to just, boy, some hypothetical of we wish it wasn't there. For my point of view, the site has been disturbed. I've used the word tortured for 100 years for residential and the appurtenant units and shoreline access. Yet wetland B persists. It's there and it's delineated and outlined. So in that sense, we're avoiding it. We're not proposing to just treat it as de minimis, pay our way out of it, pay an in lieu fee or a mitigation. It's the avoidance.
Okay, thank you. Where am I? 320. Blah, blah, blah. 320B, as in boy. That's I'm sorry, SMP Appendix A, 320B. Except as otherwise permitted herein, alteration of any wetland buffer is prohibited. How does that fit into our case here today?
In two ways. It's the classic. If we were reviewing a project proposal in a pristine site with undisturbed buffers and wetlands, and there was a proposal for avoidance, the sensitive area would have to be identified, the buffer identified, and essentially remain. This site is highly disturbed. If you plot all those required buffers, I would offer parcel 035 and 040 are all disturbed. So in that sense, it's two different paradigms. We're two different starting points. In the current condition, we're not required, or is anybody, to return it to pristine condition, then develop it. And so that's the primary difference. And B presumes a scenario where all of that natural is there. It talks about a standard buffer, a minimum buffer, or I'm sorry, just a buffer for the different categories, 75 feet in this case. And the project review includes that is entirely disturbed. That's essentially lawn.
Yeah.
And it talks about alteration. And so in that sense, and it's specific to wetland buffer.
There's even a corner of the house that's in the 75-foot buffer.
Yes. So to me, it's a different starting point, and we don't have to go back to the
Okay.
pristine starting point and then request an alteration.
Is the project proposing buffer averaging?
It is not.
Okay, I didn't think so. Is it proposing buffer reduction?
For the stream buffer, yes.
For the wetlands?
No, sir.
No. So it's relying entirely on that 330A exception clause to avoid consideration of either buffer averaging or wetland buffer reduction. Am I right?
Generally, yes. And if you look at 220, or I'm sorry, 320, section E at the top of page A18,
Mm-hmm.
it demonstrates more that portions of this development regulation pertain to undisturbed natural sites. And there's a specific standard, not less than 75%. So if the table in 320 requires a 75-foot buffer and it was undisturbed, the shoreline administrator may reduce it to not less than 75% of the standard. And so to answer your question, we're proposing that's entirely already lawn. We're not,
Okay.
the buffer is a line on the exhibit. The actual in the field buffer is lawn.
Yeah. Is Lake Washington a priority habitat?
Yes.
Then let me go to 16, back to the code.
Yes.
16, 16, 320. And well, this is in the code. A1A, 320, A1A. Talking about a relatively undisturbed vegetated corridor, at least 100 feet wide, protected between the wetland and any other priority habitats within 300 feet of the wetland. Would it now? You've said that if there's a provision in 1616 that's more restrictive than the comparable provision in the SMP Appendix A, that we pull in the more restrictive provision. Am I,
If it applies.
if
So
it
for the
applies?
shoreline with public access and the goals in the comprehensive plan portion of the SMP, that's what we're trying to achieve. The section in the Lake Forest Municipal Code is a scenario to preserve natural citywide, but doesn't apply to this site because the permitted uses, the shoreline reasonable use and so forth, the public access definition, it's a different scenario. So there are many sections in the Lake Forest Park Municipal Code that would conflict with a specific section in the SMP, but they just don't apply.
Okay.
A classic example that I use in meetings is tree canopy. The SMP does not, it has requirements, goals, policies for tree preservation and replacement, restoration, does not contain a tree canopy percentage. The Lake Forest Park Municipal Code does. So that's not a conflict. That's a standard in the municipal code that would apply to these lots. And in this case, the R-7.2, it's 28%. I just offer that as an example.
Okay. There is, according to the plans, a sewer line that I believe is called the Kenmore Interceptor that's out under the bed of Lake Washington, I don't know, 50, 100 something feet offshore. And am I reading the plans correctly that there is another sewer line that crosses apparently all three of the parcels in this project from east to west, and it's above the water line. It cuts through the grass.
Correct. That's a sewer lateral to the city sewer surface in the ground landward of the ordinary high water mark. The first one you mentioned is a regional trunk line in the lake bed
Okay. Do you happen to
or on the
know
lake bed.
how many houses further down Beach Drive are connected to that lateral?
I believe it's 5 right now, but I've read somewhere in the record that at some time it was 10.
Okay.
I have not researched that number, but 5 or 10. And then the city ends eastward of there, and then that's the open space in Logboon Park.
Okay. And it's that sewer line, not the regional trunk line, that there is consideration to replace apparently with one that would be beneath or within the right of way of Beach Drive.
That correct. That's the
Yeah.
CIP project to replace that
Okay.
aging lateral.
Thank you. When I was hearing the application for the, I think it was a CUP and a shoreline substantial development permit for what we now know as the preserve back in 2002. I had a finding that the city council had adopted a master plan for the development of that park. And it was in, I had a background paragraph that sort of gave the history of how this thing came to be an application. And one statement in there was that the city had a master plan and that the council had adopted it, I think at the time, several years prior. Has the council, I know from what I've had in testimony that the council has taken certain actions to facilitate the development of this project. Does it have a master plan? Did the council approve a master plan for the consolidated park?
No, sir. They've approved a comprehensive plan in December of 2024 with a vision, goals, policies that support this, but it does not refer to a Lakefront Park Improvements master plan. The prior testimony was that they needed the specific expertise to design and permit a public park at this site. And that's the contract with Facet. In administering that contract through the city administrator, the council has taken that role. Contract, grants, design, and I believe the testimony was schematic 1, schematic 2. What should be built there? And so that's been their input. But
Okay.
there's also testimony they don't play a role in the review or decision for the park.
Well, I fully realize that. Yes. Now, the one question I'm looking at now is one I should have asked one of the wetland people before, and so I'll wait and see if they show up again. Appendix A, this would be SMP Appendix A, 120. Let's see, there's chapter 8. Okay, 120. I don't think, yeah, I didn't write down the page number on this, so bear with me. I've got to scroll through it. There's 60, 70, 80,
Try
110. Here's
159.
120. Here's 110. Thank you. Yes, it is 159. Thank you. 120C 5. This is in mitigation and monitoring. The applicant shall submit a monitoring and maintenance program prepared by a qualified professional. And then C5 says, a signed copy of the written contract with a qualified professional who will perform the monitoring program. When does that happen? There isn't one now, is there?
Now, there is no such contract, and it happens later in the process. This is a higher permit decision in the hierarchy. If the CUP and the shoreline variants and so forth are not approved, that step would not be performed. So I believe on the first day we talked about the drawings and what was needed to make a judgment call on this versus construction drawings for building permit, clear and grade permit, right-of-way permits, tree permits, ministerial permits. Those are of a nature that come late in the process, but prior to the commencement of site disturbance. That's when it would happen. And I view those as ministerial permits that ensure conformance with the higher hierarchy decisions.
Okay, thank you. The zoning code in 18.54.040 A1 says that no structure in a city park may be closer than 25 feet from the perimeter lot line. Is this, what do they call it? A kayak rack? Is that an above ground thing? I'm not quite sure what I have seen a kayak rack that a homeowners group built and it was above ground, but I don't know whether that's what's the kind of thing that's being talked of here. If it is, it's well within 25 feet of the property line, and that would be contrary to city code. And
Well,
I would then be saying,
if you're
can it be
talking about the
moved?
eastern portion, that's in the shoreline jurisdiction. So, and so
So
you're,
you're saying because the part of the property that's within the shoreline jurisdiction just plain can totally ignore the conditional use permit requirement for a CUP to build a city park?
no, sir, I'm trying to find the section that you are referring to. I'm in
Okay,
1854.
right. 040. Let me try and
Before,
catch up to you. Um,
No,
18,
no 040. 030?
50,
oh, wow, no.
54, 040. There
048
is
maybe?
no 040. Okay. I obviously wrote something down incorrectly. Let's look at 030.
For you.
There is a reference to a 25-foot
That's not
setback
it.
in 048 of 1854.
Ah, well, my handwriting's not real great. I probably tried to write an 8 and came up with a 0. 048, A1.
A1.
Yes. Any building or structure on the site shall maintain a distance not less than 25 feet from any abutting RS or RM classified property.
Yes, I see it.
Um, are you saying that that provision does not apply to the east part of this project?
I'm not saying that. I can say that you can consider that it applies. That I'll start with that area, and similar to my tree canopy analogy, that area is in the shoreline jurisdiction. We've already had testimony and so forth about structures, setbacks, and intent. And then if you go further and say there's a Lake Forest Park municipal code standard that applies to the situation, should it be considered? My answer is yes. But is it a structure? Is it a building? Is it enclosed? Does it have a roof area?
Well, a
Um,
structure doesn't have to have a roof, does it?
it depends on the context. If you view it from the building code, enclosed roofed area, and so then the next layer is, does it require a building permit? I'm not sure it does. And I have to admit, I don't know the final design of that
Okay.
equipment or structure to determine whether it's equipment or a structure.
Well, God bless its pea-picking heart, the zoning code does not define structure.
I know the building code does, but yeah,
I don't think I've ever seen a zoning code that doesn't define structure.
I think it
Because
defines,
there's usually a big argument between what's a building and what's a structure.
yeah,
And in most zoning codes, the difference is one has walls and a roof, and the other is just something built up of parts in a ordered fashion.
yeah. And fence is a classic thing. At some point,
Yeah.
a fence needs a building permit at 8 feet in height and so forth, but is it a structure? No. So it's just kind of where it
Well,
falls
that's
in that spectrum.
yeah. See, I'd say that a fence is a structure. Um, but it's interesting. The city zoning code defines structural alterations, but not structure. So we are left to our own devices and desires. Interesting. Okay. Are the last question, are the buildings that remain, which would be the house, the garage, and the building that's going to be the annex, if I remember correctly? I think they're the only ones that remain intact. Are they non-conforming? because they're all built within a wetland buffer?
There's two types of nonconformity in the SMP and the municipal code: nonconforming use, nonconforming structure. They would be nonconforming structure if they didn't maintain the required setback. They are existing, they're planned to be reconstructed, not intensified. So in that sense, there's no issue. We're not proposing a new community flex building. But we would have to identify the nonconformity. If there was a required natural buffer and that corner went in, that
Okay.
would be an existing structural nonconformity.
Are they subject to, let's see if I can jump here quickly, 49. Doesn't work. Yes, it does. SMP PDF page 49, and then going on to 50. Section 3, which is on page 50. Oh, 3.9A.
Do you have the SMP page versus the PDF? Is it
I
page
do, 47.
47? Thank you.
Yeah. Yeah, 47 on the document, 49 on the PDF, and I don't think it's got a Bates number because it's the code.
I see section 3.9 is nonconforming use and development standard.
Right. So structures that were legally established and are used for a conforming use. I think that would describe all of those structures that are remaining.
Yes, and number one, yes.
Yeah. But they're non-conforming with regard to setbacks, buffers, or yards, area, bulk, height, or density. May be maintained and repaired and enlarged or expanded, da, 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 da. Do those restrictions, do they create these as, it says setbacks and buffers, so that must mean buffers from critical areas,
Correct.
because setbacks would be a zoning term primarily, and yards would be a zoning term, but buffers would be a shoreline type term.
Correct.
So they're non-conforming. It says they can be repaired, they even can be enlarged, as long as the enlargement doesn't increase the extent of nonconformity by further encroaching upon or into areas where it wouldn't be allowed for new development. Now, with the house, we're actually taking part of the east end of the house off, right?
I believe the chimney and an architectural feature, yes.
We're not pushing out in that direction.
We're not intensifying the nonconformity, correct?
Yeah, okay. And I'm sure there's a better word for it, but the toilet structure with the four toilet stalls, rooms, that's a lot smaller than the existing garage, so we're shrinking that building.
It's not increasing, yes, correct.
Yeah, and the annex, it's basically staying the same.
I believe so, yes.
Okay.
And then there
And the
was,
picnic shelter, now that building has been torn down to the subfloor level.
I believe so, along the parcel line between
Yeah,
035 and 0, or
between
040
the
and 050.
preserve and the Turner property.
Yes.
Um, so, and the new, I'm presuming that subfloor structure that's left over is going to be taken out, and probably the picnic shelter is going to be on a slab, so it's accessible at grade.
I believe so, yes.
Yeah, so if I remember, that's what the pictures look like. Um, and that's using the same footprint, correct?
I believe it is, yes.
Okay, so that's not extending into anything. Then we can ignore number two, because they were not destroyed by fire or an act of nature or an accident, so we can forget that. If they're non-conforming with regard to use regulations of the master program, they can continue. Then it said they shall not be enlarged or expanded, except that non-conforming single-family residences, da 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 da, may be enlarged.
Landward, yes.
Yeah. Okay. All of these rules, it gets very fascinating in a shoreline area. Um, I think especially so, whereas here, the decision makers chose, and I'm not saying it's a bad decision, but I've seen it done both ways. They chose to essentially incorporate critical areas regulations as a slice in time. At the time they did the master program, they took probably the city's regulations, tweaked them a little bit to refer to shoreline things, and took them physically and put them into the master program. And then in this case, about 4 years later, the city completely redid its critical areas regulations, and it's got stuff in them that's quite different from what they've got in the shoreline version. And so you have the fun every day of dealing with two different sets of critical areas regulations, don't you?
I do, and then the requirement is that they are periodically updated. Our plan is to update the critical area ordinance again, and then the SMP after that for the when the grant round comes around.
Okay, yeah, I think the WAC says that King County and its cities are due up next to update their SMPs in 27.
Yes, and the wrinkle is that ecology is undertaking rulemaking right now. So their advice is wait for the rulemaking. Then there is likely to be a grant round, and that's when we intend to update the SMP.
Okay. I started working for Snohomish County in the planning department about 6 months after the SMA was adopted. And I lived through the ratification process during the following year's election cycle, where the two different versions of the law were presented and the public chose, yes, we want shoreline regulation, and yes, we want the one that has ecology having a heavy role to play in it. The other one was entirely local. There are times when I wonder how things would have been if the public had chosen the other version, but doesn't help us here today. I think those are all the questions I have for you, Mr. Hoffman. I appreciate your patience with me. Um, let's do our mid-morning break before I go back and see if anybody has redirect. It's 11:01. We're at recess until 11:15. Thank you. This is the second half of the morning session on day 9. Ms. Pratt, do you wish to redirect any questions to Mr. Hoffman?
Yes, please.
All right, go ahead.
Mr. Hoffman, the hearing examiner was just talking about setbacks. So I want to ask you how a particular item in the SMP applies here. So this is the SMP section 5.3, the Shoreline Residential Environment. And I'm going to take you down to the development regulations, which start on page 57 of the SMP. And in D, it's entitled setbacks. Can you tell us how that applies to this project?
Thank you. Yes, the greater section or chapter is Shoreline Residential Environment, which is the two parcels. The designation, development regulations, A, B, C, D, and then I could read the screen.
Oh, I'll make it bigger, sorry.
Thank you. D1 talks about setback from ordinary high water mark. I believe in chapter 7.1, it talks about a 50-foot standard setback from ordinary high water mark and landward from ordinary. And A or B would apply. And in that required standard setback for residential development, and B applies. Development associated with public access and ecological restoration is not required to meet minimum setback. However, where such development is approved within the minimum setback, the placement of structures, storage, and hard surfaces shall be limited to the minimum necessary for feasible operation of use. So I believe in that standard setback, shoreline setback, the pathways are the only thing that are proposed in there.
Okay, let me show you a different exhibit. First, let me just take you to the where it tells us it's a 50-foot exhibit, 50-foot setback. So we are in chapter 7, regulations in 7.11, and looking for the 50-foot setback. How does F1A apply to this project?
The greater chapter is 7.11 residential development as the applicability exemptions policy, then bulk regulations for development, and then F in addition to the underlying requirements for residential development, comma, the following standards shall apply. A 50-foot standard setback shall be established from the ordinary high water mark. So I believe one or many of the exhibits show ordinary high water mark and then a standard 50-foot line landward of the ordinary high water mark.
Okay, let me show you another exhibit.
Sorry, what page was that?
PDF 100.
Thank you.
I'm pretty sure that was, I was trying to read the number on the margin and I think it was PDF 100.
It is PDF 100, page 98 of the SMP. This is Exhibit 22 in the record. Does this show you that 50-foot setback from ordinary high water mark?
22 Lyon Creek Stream Buffer Exhibit. Yes, it shows dash line for ordinary high water mark and then the darker line right there. That's the standard shoreline setback.
Okay. And are any structures proposed within this setback?
No structures proposed landward of the ordinary high water mark except for a paved path.
Do you consider the paved path a structure?
I do not.
Okay. I'm sharing Exhibit 42, Bates page 1047, PDF 21. Can you identify on the bottom row of pictures, um, the second from the right, what this is?
Uh, I have my
I can make it.
numbers mixed up, but no, I could see the photo. That appears to be an example of a kayak rack.
Okay. And would you consider this kayak rack a structure?
For planning and building, I would not.
Okay. And do you know, is this the exact kayak um, structure that's planned for the park? Or is this an example?
It's an example. Yeah, we have not made that decision or procured it or even researched how much that costs.
Okay. This is Exhibit 39, the staff report. We're down into the conditions on page 1007, PDF 49. Can you tell me what condition 19 is?
Those are the wetland monitoring performance minimum standards that would be used later in a monitoring plan uh, as part of clear and grade or any of the ministerial permits. This is a draft condition of approval that would implement the monitoring section in the CA report.
Okay. Um, you testify quite a bit about access to wetland B. What kind of access will people have to wetland B? What will they be able to do?
The testimony up till now, it's my understanding that the draft condition can be augmented or revised by the hearing examiner, but it includes signage to some extent every 50 feet or less. That it may include fencing, but fencing's not proposed. I would offer that the chicken wire should be removed, but it is not part of the enhancement or any plan to get rid of the invasives, but to avoid um, uh, erasing it for a better lack of a term or mitigating or in lieu fee.
Sorry, I have to find a definition I wanted to use and I'm not finding it. Mr. Examiner, I'd like a 5-minute break so I can find what I apologize, did not have marked in my SMP.
Were you looking for the definition of structure?
No.
Okay, because I found that just
Oh, good.
just a minute ago. And even though that's not what you're looking for those who are curious, it's found on PDF page 28 of the SMP. And yes, you may have a 5-minute break.
Thank you.
It's 11:30. We'll reconvene at 11:35. Thank you. Our 5-minute recess having run its course, we are back in session. Ms. Pratt.
Thank you. All right. When you're in a hurry, remember that there are definitions in 2 places in the SMP. One of them is in Appendix A, Section 40, definitions. A is the definition of alteration. Mr. Hoffman, the access that's going to be allowed that we anticipate happening on wetland B, does it amount to an alteration of wetland B?
It does not.
Why is that?
The definition here in Appendix A, alteration that applies means any activity that results or might result in any impact upon a sensitive area. And then a semicolon, provided that alteration does not include walking, comma, fishing, comma, or any other passive recreation or other similar activities.
Okay. Um, if the final decision in this case from the hearing examiner says that there will be 12 off-site parking spaces at City Hall, will that be binding on the city as the applicant?
Yes.
Okay. That's all the questions I have. Thank you.
Thank you.
Thank you. Any recross, Mr. Haniker?
Yes, just a couple. So, first of all, really quickly, you mentioned, and I can pull it up if you'd like, but condition 19 in the staff report regarding the monitoring program. Is that condition a part of the MDNS?
If you're referring to, I believe, the first 10 conditions of approval in the staff report, those are carried over mitigation conditions from the MDNS, and it is not part of that.
Okay, 19 is not part of that.
Exactly. It was not a mitigation measure carried over from the MDNS.
Okay. Okay. Share my screen. We are back in the master program. And I'll refer you to, this is page 28, PDF page 28, actual page 26 of the SMP. And there is a definition of structure in the master program. How does this definition compare to the definitions in the building code?
The first part is consistent. A permanent or temporary edifice or building is very consistent. Building code talks about enclosure, roof area, floor area ratio, things like that. And then the permits are issued the building permits are issued in compliance with that. So most setbacks are measured to that type of structure.
But you said the first part is the second part after the or, any piece of work artificially built or composed of parts joined together in some definite manner. Is that the same as the building code?
It is in my perspective because of how I use the word structure and the actual permitting that allow construction. It's consistent. But I admit it can be read to anything, including artwork or a model. But what I don't think it implies is equipment or artwork or lawn art or any other things that are otherwise defined.
But it is more expansive than what is in the building.
How I use it, yes. Artificially built or composed of parts could be a car.
So with that with the S&P's definition in mind, do you think the kayak rack would be a structure?
I still do not. I think it's equipment.
Okay. What about there is a deck on the plans for the event building, the community center, correct?
Yes.
Is a deck a structure or an expansion of a structure?
It becomes a structure for my purposes when it's more than 30 inches above grade.
Do you know off the top of your head how far off grade the deck is in these plans?
I do not.
But a deck that is more than 30 inches off grade would be an expansion of a structure.
I don't know what that means, expansion. If a deck exists and it's more than 30 inches, it's not an expansion.
A new deck, then.
If no deck was there and you were proposing a deck at 40 inches above grade, that would be a new structure or a new element, yes.
Okay. No further questions.
Thank you.
Thank you. Thank you both. Ms. Pratt, who would be your next witness?
Mr. Hoffman was the city's last witness on our direct case.
Okay, thank you. In the normal flow of things, we would now hear from public testimony. I know that over the course of the 9 days, 8 preceding this one, I've allowed public testimony at several points, trying to make life more pleasant for the members of the public. There is, according to my looking at the list of attendees, there are maybe 1 or 2 people attending who have not testified. And in an abundance of caution and trying to give members of the public the best opportunity I can to participate in this hearing, I'm going to ask if there are any members or any participants, strike that, any attendees who wish to testify at this time. And I'm looking at a list of 1, 2, 3, 8, 7, I think. Yeah, 7 attendees. Of them, Jesse Fudge has already testified. Tyler Fudge has already testified. I would assume that TJ is the same thing as Tyler Jeffrey Fudge, although I'm not quite sure why he's listed twice, but that's my guess. I do not believe we have heard from Roan Hohenfeld. Mr. Kane has submitted a letter. Frankly, without going back and looking through my about 25 pages of notes, I can't remember whether he's also testified. And Josh Rosenau has not testified, and the mysterious E, whomever that is, has not testified. So if any of those folks want to testify, please click the little button on your screen that says raise hand, and I will call on you. Mr. McLean will make it happen that you pop up on the screen as a participant if you want to testify. I'm not seeing any little symbols showing up, so I'm going to pass over that for now. Mr. McLean, you're there at City Hall. Is there anybody there with you doesn't look like it, but is there anybody there in the public who wishes to testify?
No, there is no public members here.
Okay, thank you. Then we will pass over that. Now, that brings us to rebuttal. Do either of you folks wish to present rebuttal witnesses? Let's see where we're going here.
The Fudges do not have do not wish to present rebuttal witnesses. We would reserve the right to do so if the city to rebut city rebuttal witnesses, but otherwise we do not.
Okay, thank you. Ms. Pratt?
No.
The city does not. Okay. We may be rapidly moving towards the conclusion of this process. There being no rebuttal, the next thing in the schedule would be closing. And I understand from a day or two ago that you folks have already decided that you would like to do written closing, which is perfectly acceptable with me. My rules of procedure have sort of a pro forma schedule for doing that. It gives each principal party 1 week to prepare and submit, and the order in which you do that is the same order that would be followed if we were doing it orally here in the hearing room, which would be it says applicant, respondent, appellant. Applicant and respondent are one and the same. So it would be city first and the Fudges second and last. Does that normal sequence satisfy the parties?
It works for the city.
That'll work for the Fudges as well then.
Okay, so city and then Fudge. And let me get my calendar. We are sitting here on the 10th of March. If we stuck with the rule of procedure, the city's closing would be due on St. Patty's Day, March 17th. And then the Fudges would be due on March 24th, which is no holiday that day. That's just a regular day. Ms. Pratt, is March 17th acceptable?
It is.
Okay. And Mr. Aneker, is March 24 acceptable?
Yes, March 24 is acceptable.
All right. Now, we will momentarily be closing the hearing. At that point, we will not accept any additional evidence from anybody. So if the city gets more things dribbling in this afternoon, um, sorry, you can tell them that it will not be a part of the record. If the city happens to have some comments that have come in this morning that you're aware of and you want to enter them, let's do it now or forever hold your peace.
I do not see any. David, do you mind explaining if you have received any and just haven't had the opportunity to forward them to me yet?
I,
Thank you.
yeah, I just checked my email. There are no new comments this morning. No new public
Very
comments.
good. Very good. Thank you. Then I think we are,
One more
sure,
item
question.
for the closing arguments. I'd like to propose a word limit.
I would love to have a word limit.
I'm going to propose 4,200 words, which is the word limit for a regular motion in King County Superior Court.
Mr. Aneker?
I would. How does that compare to the word limit in Superior Court for a motion for summary judgment? It's what I am thinking is more appropriate here. I should know this off the top of my head, but I do not.
I would have absolutely no knowledge of it, so I am relying on you two folks to.
Okay. Motion for summary judgment is 8,400 words, so essentially twice that long. That is
Roughly,
probably longer than we need.
roughly how many pages is 4,200 words? Because you're doing this on pleading paper, so it's sort of
Pleading
double
paper.
spaced.
I'd say it's usually 8, 10, usually around 10, I think.
And I think I'm going to need more than we're going to need more than that, just because there are, as we've seen, some legal issues that are relevant to the hearing examiner's decision.
We're always arguing legal issues in motions. What about 5,000 words?
Let's go to 6. How does 6 sound?
It's up to the examiner.
I'm enjoying watching the negotiation go on here. I'm just hoping I don't have to plop in, but I will.
I think 6,000 is not necessary, but that's fine. Need 1,000 more words.
6.
And watch, I'll turn in something that's 4,500, but
6,000 it is.
6,000.
6,000 words. And I'm not going to make this a rule because I'm sure you would, but I beg you don't put those 6,000 words in 10-point type or something really teeny like that. I like the word count better than the number of pages because there's no motivation for you to go down a 10-point type or something like that. Okay, then we have concluded the hearing. Further testimony and evidence is not permitted. We have closing statements, which the parties at their request are going to submit in writing. The city will have until close of business, which would be 5 p.m. on March 17th to submit its. The Fudges will have until close of business, 5 p.m. on March 24th to submit their closing statement. Each closing statement is limited to 6,000 words. And as far as I'm concerned, I don't know whether you're thinking this way or not, but your your titling information would not count as far as I'm concerned. Your signature information at the bottom would not count, and your distribution, if you have your clerk do one of those pages that shows to whom he or she sent it, that would not count. So I'm talking body of the document, 6,000 words. You folks have my email address, and I would encourage you to use my email address. You can send it to everybody who's on the email distribution that we've used procedurally in this if you wish, but definitely needs to go to the city, the opposing party, and to me. And I would appreciate that. Anything further? No? All righty. Then I thank you all very much. This has been a most interesting hearing, and you've given me a lot to think about. So we'll see how it all goes. I thank you all very much. It is now 11:55 a.m. We are adjourned.
Thank you, Mr. Hearing Examiner.
Thank you. And Mr.